Good morning. I am so excited to be here from these panelists today. So let me start with introductions. To my immediate left is Professor Rob Schwartz, Professor Emeritus at the School of Law. He is faculty here and has been faculty since 1976. Shortly thereafter, after coming to the School of Law, he decided to focus on health law. His work presently focuses on the areas of end-of-life care, death and dying, managed care, and the application of civil liberties principles to the healthcare enterprise. Professor Schwartz has been working on aid in dying since the first New Mexico bill made it through the first Senate committee in 1996. To his left, Scott Fuqua is a 2001 graduate of the University of Chicago Law School and the former Director of Litigation Division at the New Mexico Attorney General's Office. While at the Attorney General's Office, Mr. Fuqua represented the state and various of its officers in litigation, raising a host of constitutional questions. He was supposed to be trial and the appellate counsel for the state in the Morris v. Brandenburg case. To his left, Judge Hennessy. Judge Miles Hennessy received his JD from Pepperdine University School of Law in 1993. Hailing from Taos by way of New Orleans, he was an assistant United States attorney from 1996 through 2007. Judge Hennessy was appointed to the New Mexico Court of Appeals in 2011 and served on the Court of Appeals panel that decided Morris v. Brandenburg, submitting a concurring opinion. And to his left, Chief Judge Linda Banzi received her JD from the University of New Mexico School of Law in 1995. Ever since commencing law school, she has been interested in state constitutional law, particularly with respect to the rights it affords individual New Mexicans in civil cases. Judge Banzi served as a district court judge in the Second Judicial District Court from 2004 until she was appointed to the Court of Appeals in 2008. She's the current chief judge of the New Mexico Court of Appeals and also served on the Court of Appeals panel that decided Morris v. Brandenburg, filing a dissenting opinion. I will be sitting to join the discussion this morning. But I will start with a question to one panelist, and perhaps other panelists will want to respond as well. I do have different questions for different panelists, but I do want this to be a discussion for us. And also, I hope to have time for questions and answers from the audience. Let's start with Chief Judge Banzi. Into this. Does recognizing a right to physician aid in dying necessitate that the right must be available to everyone, even when a duly appointed surrogate makes a decision, or even when the patient is unable to self-administer the life-ending medication? Or can it be confined to the individuals who meet certain requirements, such as the individual must be competent or be able to self-administer the medication?
Professor Suzuki, this is an easy question to answer. I can't. I'm limited to speaking about the opinion and the dissenting opinion that I wrote, and I think probably Professor Schwartz or Mr. Fuqua are better equipped to answer that question, unless Judge Hennessy thinks he wants to answer it. No.
Being a professor and not a judge, I don't quite understand judicial ethics, so this might happen a few times during this hour that I will ask questions that the judges may be able to get out of. But we do have other panelists who might want to answer this question. And for those of my students who are in the audience, I know that you're now feeling a little glee because this is what it's like in class when I call on you. Here we can call on the panelists. So, Professor Schwartz or Mr. Fuqua, would you like to answer that question?
That actually raises a question that I had to think pretty hard about in the way that I approached the defense of the statute, because the manner in which the right was articulated the right of aid in dying, it already came with some, I don't want to call them labels necessarily, but it came with strictures already. A person had to be mentally competent. The person had to be terminally ill. So there's already limitations on the availability of the right. And one of the things that we had to think about over at the Attorney General's office at the time was whether those were differences of a constitutional dimension. And this was actually something that came up in the oral argument. I recall a question, I believe it was from Justice Daniels to Ms. Shower-Ives during her presentation about, the ability to self-administer the drug. Is that really a difference of constitutional dimension? And, one way to approach the question is to say, well, yeah, sure, it should be available to everybody. You shouldn't have to be terminally ill. You shouldn't have to even be mentally competent. That everybody should be able to take advantage of the opportunity to get that kind of prescription if they feel like that's the right thing for them to do. Who are we to second guess that decision making? And so like I said, the way that the right was constructed already contained those inherent limitations. And from my perspective, I think it has to, because otherwise it starts to look like a pretty unpalatable decision. Even though the court's not supposed to be making policy decisions, this case, I think, highlights sort of an interesting intersection between what it is the legislature is supposed to be doing and what it is a court is supposed to be doing when it's applying equal protection or due process jurisprudence that requires a determination about the strength of a state's interest, whether it's strict scrutiny, intermediate scrutiny, or rational basis. Court's asking a question: is there a reason, compelling, important, or just a reason to take this particular step, to curtail this particular right, to draw this particular distinction? And even though courts aren't supposed to be sitting in judgment of the wisdom of legislative enactments, when you're asking those questions, it's kind of hard for me to see what else it is that the court's doing, other than sitting at least in one dimension in judgment of the wisdom of that particular enactment. So I'm getting a little bit far afield from the question that you asked and taking an inordinate amount of time doing it, but to me, I don't think the case becomes palatable along constitutional and certainly along policy dimensions if the argument is everybody under any circumstances should be able to obtain a lethal prescription. I think it has to be cabined in the way that it was cabined, but I think that leads to some of the other things you're probably going to discuss with us about the difference between the judiciary being the one making this determination and our policy-making body, the legislature, being the one making that decision. So I don't know if that answered your question at all, but...
It's like class, the students answer, and I'm always excited about the answer.
And I mean, I agree with Mr. Fuqua, and it does seem that the underlying question is, if a patient can make this decision, then as a constitutional matter, must a surrogate be able to make the same decision? That's really, I think, the underlying question. And from a constitutional point of view, I can't see how you can get that far. We know there are rights individuals who are competent can exercise that others can't. For example, the right to vote. You can't, in fact, appoint someone to vote on your behalf. There's no constitutional right to have a surrogate, to have a proxy cast your vote. So it may not rise to the level of a constitutional right to appoint a surrogate to determine that you have a right to aid in dying. It could, of course, be a statutory right, and I think under the Uniform Healthcare Decisions Act and the principles that underlie the Uniform Healthcare Decisions Act in New Mexico, there would be a good reason to allow for people to designate surrogates to elect aid in dying on their behalf in an advance directive. That makes a lot of common sense. It can be done in other countries. It's just, it can't be done in any state in the United States now, but it can be done in other countries. But I agree with what we just heard, that in fact we have to distinguish that as a constitutional right that we could expect the Supreme Court to recognize, and as a statutory right that we would ask the legislature to recognize.
What I can add is that is a hypothetical question, but the issue in Morris was very, very narrowly defined as whether or not a mentally competent, terminally ill patient could seek aid in dying. The lawyers in that case were not trying to seek broader constitutional rights in any other way, but except for a very small class of people.
No, I think that that's true, and I think the Supreme Court went far beyond the question it was presented with in actually addressing the question of the right of a surrogate to make a decision in the Supreme Court opinion.
You know, one of the things that I will say, and one of the things that the majority opinion was concerned with, and my dissent was concerned with, I wrote in my dissent that that the constitutional right is neither absolute nor unqualified. That is, it would be, if it existed, conditionally available to certain citizens but not to others, which is inconsistent. My point being that it is inconsistent with many constitutional rights which are available to all citizens. So I think it's fair to say that, because it is in both opinions, and it was a concern of the majority of the panel, or at least which I joined half of.
Now you're going to have a debate with Judge Hennessy and myself.
It's not the first.
No, it won't be the first, it won't be the last. And in the dissenting opinion, I made clear that many constitutional rights are recognized, and this constitutional right, the dissenting opinion proposed, would be recognized for all New Mexicans. Just because all New Mexicans may not choose to exercise that right does not mean that it is not available to all of them. Many constitutional rights are found and are in the Constitution that everybody may not exercise. The right to an abortion, the right to marry, the right to use birth control. Those are constitutional protections available to all citizens, but that all citizens may not use at all times. And so true also for physician aid in dying. It would be a right available to all mentally competent, terminally ill New Mexicans, even though not all such people may choose to exercise that right.
I have no rebuttal.
And of course, there is a way that the New Mexico courts could have moved in that direction. The New Mexico courts didn't have to say, there is the right and here are all the circumstances in which it actually applies. They could have done what the Supreme Court in Canada did, just about the same time that our Supreme Court was acting, and they could have taken a path that our Supreme Court has taken under other circumstances and say there is a constitutional right. We're going to recognize that it's a constitutional right. We're going to recognize that it also needs to be cabined in some reasonable way, and we're going to ask the legislature to, in fact, find the limits, find the corners of this right. But we're going to recognize as a court that there is some underlying fundamental liberty interest here and a right that we will enforce. And again, that wouldn't be anything so surprising or so new for the court to do that. The New Mexico Supreme Court's done that before. As I say, the Supreme Court in Canada in Carter did that with this very issue.
So, Professor Schwartz, because I think that justices won't answer this question, Mr. Fuqua, perhaps you could answer this question as well. In regard to the Canadian Carter decision, so you think that the New Mexico Supreme Court could have given some kind of mandate in its opinion for the legislature to work on an aid in dying policy?
Sure.
Statute?
I mean, sure, that is one thing they could have done. And you think about the Hicks case in New Mexico, that was a change in common law, but the court said it's going to be difficult for us. That's the end of sovereign immunity, at least under many circumstances in New Mexico, the modification of sovereign immunity in New Mexico. And the New Mexico Supreme Court says, well, it's going to take a while to have in place some actual guidelines, some actual statutes that we need to carry our decision into effect. We don't know the limits, the precise limits of the rules. We don't know exactly where the lines should be drawn as a practical matter. That's going to require months of legislative hearings. There are a lot of legislative decisions left to be made. And we'll recognize the right. We want the legislature to know that if you don't act, then in fact we'll start drawing those lines. But you actually have the tools to be able to make those kinds of decisions. You can hold those legislative-style hearings and get to the legislative-style facts in ways that we can't. So we will, in fact, let you know that you have, in Canada it was 12 months, then extended to 16 months. You have a time period to create the statute to carry our constitutional right, our fundamental right into place, into actually to fruition. And that could have happened here. You know, I feel this is unfair. It's a unique position to be in where the judges can't respond. The judges normally get the final word. This is since I was a candidate for both Judge Vancey's seat on the court and Judge Hennessy's seat on the court.
Payback.
This is the only kind of vengeance I'm ever going to get.
I do want to add, though, my recollection, at least when this was argued before the Court of Appeals, was there was no request to take any time to let this go before the legislature. And in fact, the record below established, it was an uncontested record, undisputed facts, that established that a standard of care has been established that could be followed and that would not be problematic in this case. So if the legislature wanted to act, it certainly could have, but there was no request to do that given the record below. The other thing I would mention is, our U.S. Supreme Court doesn't wait for Congress to act when it determines that constitutional rights are available. It didn't do that in Roe v. Wade, and it has not done that in other cases. So to the extent it wasn't asked for here, it was certainly not a matter for consideration in the Court of Appeals.
Well, I'll say that I was fascinated by the Canadian approach, which was to find the existence of a constitutional right and hold off on the effectuation of it in order for the legislature to address it. And I just asked Judge Vansey if she had any memory of whether any such request was made in this case. We were confronted with an all-or-nothing determination, which she's right, is consistent with the sort of determinations that courts are asked to reach all the time. And without getting, the best expression of my resolution of the constitutional issue is in the little 11 pages I wrote, which many of you probably overlooked. It's bookended by a very lengthy majority opinion and a soaring and articulate dissent. So I forgive any of you for not having read it. And it's one of those instances where being irrelevant has its advantages, because many of you are still my friends and still talk to me. After what I wrote, but I joined the majority's conclusion that there was no federal right, which I thought was easy enough under Glucksberg. I certainly appreciate Ms. Tucker's belief that Glucksberg, and don't even disagree that Glucksberg certainly left open the possibility at some time in the future. But I also wrote that there was no state right, and I'm at least somewhat, I stand here alone today, but there were 5 Supreme Court justices that agreed with me in the end.
To me, I'm not going to pretend like I've thought about this any longer than since the question was first posed to the panel, but to me, the idea of a court saying to a legislative body, go forth and do this, and if you don't, we'll do it for you, is a little odd, because my understanding anyway of the separation of powers between those two branches is that the legislature does the legislative stuff and the courts do the judicial stuff. And sometimes what the courts do anytime a court strikes down a law as unconstitutional, it's necessarily acting in an anti-majoritarian way. I mean, it's a majority, the law they're striking down is the process or the result of the majoritarian process. But I don't think that means that the court can say, if you guys don't take action and provide some contours to the right that we've just described, then we're going to do it. I mean, procedurally, I don't even know how that happens. They'd have to have another case in front of them at a minimum, I think, to have that opportunity. And that's, I suppose, the way the common law process works. But for something like medical aid in dying, I don't know if the common law process is the best way to get us to the result that we need to reach. I took great comfort in Judge Hennessy's concurring opinion, because one of the principal arguments that I'd made from the beginning through the end of the case was that this is fundamentally an issue to be determined legislatively, and that may be something that we return to later, because there's some thoughts I had during the case just about that approach and about what it meant for me as a lawyer, and particularly for me as a lawyer representing the state. But I don't, and I'm sure there are lots of things I don't know about the way that courts properly interact with legislatures, but the idea of a court saying, you go figure this out, and if you don't, we'll do it for you, is kind of strange to me.
Well, I think it may be, however, a very creative use of the judicial power. It may be an appropriate use of the judicial power. And it's one that could have been applied, I think, to really good effect in this case. Because I think that we all agree that the right has to be cabined in some way. There are going to be some limitations. As a practical matter, there are going to be some limitations. What if there really is a constitutional right under some general circumstances, but the court, in the context of this one piece of litigation involving only a few plaintiffs, couldn't actually get the whole landscape, didn't get exposed to the whole landscape? What if, in fact, there was room for the legislature to, in fact, act afterwards? Would this be a good way of allowing the court to do what it does best and what it's, in fact, legally and morally obliged to do, to define those fundamental liberty interests and to make sure that, in fact, they were enjoyed by the people of the state of New Mexico, but then also allow the details to be worked out through a process that, in fact, will best serve that interest. And Mr. Fuqua, I took that as your arguments in the Court of Appeals and the Supreme Court, where I saw you argue, and Judge Hennessy as your the basis of your opinion, that, look, the legislature is just much better at dealing with these kinds of issues. The argument went beyond that, I know, but I think a big part of it was the legislature is much better in dealing with these issues. And you know what? It may be better in dealing with some parts of those issues. But as to the establishment of the underlying right, the underlying fundamental constitutional right, that, I think, is within the role of the judiciary.
So the question in my mind is then what happens when the court says, yep, that's a right. We're striking that down, and legislature, it's going to be up to you to tell us what the contours of the right are, and the legislature says, meh.
Let's look to Canada to see how that works.
Or Montana.
I think Montana's a slightly different story, but Montana is a possibility too. Let's look there a second. Let's look first to Canada, where it happened just like this. The Supreme Court said, you've got 12 months, Parliament, come back with something that's good. And if it's not good enough, and we really won't tell you very much about what constitutes good enough, we'll act. But they did provide basic standards. These are the kinds of aspects that we expect you to consider, and these are the limits on what you can consider as you create this right. Eventually, the legislature said, we're having trouble. I don't think we can do this in 12 months, because, in fact, it was a major political issue. There was a requirement there be consensus, something like consensus, and it was difficult to do, but on the order of the Supreme Court of Canada, the legislature felt an urgency that it hadn't felt before. And it brought people from different sides together, and it really did the analysis, and it took 4 months longer than they originally thought it would, but they developed, in fact, a statute, which, by the way, is in some ways inconsistent with the original Declaration of the Right. Those, as Professor Pope told us, are now in litigation in Canada. It's going to take another few years to work out all the details, but look at the nature of this right, and look at the complexity of the circumstances under which it's applied. That is not there's not going to be a clean answer. There's not going to be a clean opinion that describes this and resolves this forever. So I think this would have been a perfect case for the use of the device, which, I say, the New Mexico Supreme Court has used before in, for example, Hicks, but where the Supreme Court of Canada acted with this exact same issue.
And I don't want to drag this out any longer than it needs to be, which I may already have done, but your answer assumes, though, that the legislature takes some action, like the Parliament in Canada did, and in response to the Supreme Court telling it, go forth and do this. And what I'm saying is, what happens if the New Mexico Supreme Court says, legislature, it's up to you to do this, we expect you to do this, and the legislature says, no, we're not going to do that. That's not an issue we want to deal with. So you have this some kind of something that looks like a mandate from the Supreme Court directing the legislature to act, which the Supreme Court doesn't really have the authority to do, and then you just have what? I mean, it seems to me you have a vacuum that needs to be filled with some sort of policy directive, and the body that is constitutionally and exclusively constitutionally tasked with filling that vacuum doesn't do it. And then what?
We'd resolve the issue the way we resolve the issue with other constitutional rights. That is, courts are going to make decisions in subsequent cases. Doctors are going to have to decide, given the statement of the Supreme Court, what it is that they're authorized to do. The Department of Health will undoubtedly come out with some regulations. Professional organizations are going to propose standards. And all the debate which follows, that declaration of the Supreme Court that there is some right, is an incredibly healthy debate, which will lead to the resolution of this issue. And without the Supreme Court saying that, none of that happens.
Mr. Fuqua, I'm going to paraphrase here what Catherine Tucker said earlier, but she seemed to indicate you said that the state has no legitimate state interest when there is an individual who's terminally ill, competent, and is able to self-administer medication to end her life, but is unable to because she cannot get the medication, and she is suffering. What is the interest that overrides the individual's interest such that aid in dying is not available in New Mexico?
My recollection of what I said was a little narrower, but
Careful, I
But
have your exact quote right here in the opinion.
but what I remember saying, because I just don't think there's any other side to this coin, is that the state has no interest in prolonging a life that is a life only of suffering, and I honestly don't see how you could build a case on the other side of that. And let me take that as an opportunity that you did not invite me to take, which is to say that through the defense of this case, I cannot tell you how many emails I got, how many phone calls I got. There was one attorney that I'm sure Ms. Tucker knows from past experience. I don't now recall her name, but she's based in, I think in Seattle is where she was, who just was relentless in trying to convince me that the way that I needed to defend this case was in putting on the case against medical aid in dying. And it got to the point, actually, where I think at least two of the amicus briefs that were filed in the Supreme Court expressly took issue with the way that I had approached the defense of the case and said, look, Supreme Court, if you're inclined in any way to rule in favor of the appellee here, would you at least give us the opportunity to put on the case that the state didn't put on and should have? And so getting back now to the question that you asked with that context.
Do you want your quote?
I'm sorry?
Do you want your quote? then you can just bounce. Here you go. This is what you said at the hearing. Let's see, where am I? The state interest does not lie in prolonging the suffering of people who are in fact terminally ill and have made an informed, competent decision to request this sort of medication. I will readily concede that the state has no interest in preventing that person from obtaining that sort of assistance.
So Ms. Tucker may have been closer to what actually happened in my recollection. Thank you,
You're welcome.
I guess.
Have to be accurate.
So to me, it really wasn't even a question of what the state interest is that overrides an individual's liberty interest in decision in reaching the end of their life. You know, I mean, I agree with what Judge Nash said in her opinion in the trial court that, you know, when you're making the decision about how it is that your time on earth is going to come to a close and when that happens, it is hard to conceive of a more personal decision than that. But to me, it really wasn't a question about the ability to restrict a right. It was a question about the existence of the right in the first place and what its contours are. And the position that I took, and I still to a very large extent believe this, is that those really are essentially questions that the legislative sphere is much, much better equipped to deal with than the judicial. And so, again, to me, it wasn't a question of whether or not the state had an interest in preventing the exercise of the right. The question was, what is the right exactly? How far does it reach? What are its limitations? And which body of our tripartite system of government is best situated to make those determinations?
I have a follow-up question in regard to sort of your following one's beliefs, Mr. Fuqua. So what is the role of an executive in enforcing or defending legislative enactments enactment with which an executive officer disagrees?
I am glad you asked me that question. Something else that I made clear in this case, certainly at the trial court level, and I think both the appellate arguments as well, my personal policy preference is that this practice be legal. From a policy perspective, I don't see compelling arguments against its legality. But that isn't my job. And this was a difficult case for me because of that, because I was tasked with the job of defending a legislative enactment that I didn't think was a particularly good idea. But I don't get to ask whether it's a good idea. My job is to defend the duly enacted, well, it was, I don't work there anymore, but at the time, my job was to defend the duly enacted measures of the state of New Mexico. I think the circumstances under which, the question talks about executive officers, we're really talking about the Attorney General, at least in New Mexico, because that is the executive officer who performs this function. The circumstances under which I think an Attorney General could say, no, I'm not going to defend that enactment, to me, are very, very narrow. If the legislature passed a statute that said it is legal in New Mexico for one person to own as property another person, right, in clear violation of the 13th Amendment, I think, the Attorney General could say, no, you guys are on your own on that one. But when it comes down to a question of just whether or not you think as a policy matter what you're defending is a good idea, I don't mean to make any enemies in the legislature, but I defended a lot of statutes that I thought were kind of stupid. But that's the way our system of government is designed to operate, and I recognize the important role that courts have to play as bulwarks of liberty against incursions of those liberties by the legislative branch in the majoritarian process. But I think it's important, even in the context of this particular seminar, to keep in mind, at least in my opinion, the system, and when I say the system, I mean our system of government, and the roles that the different branches of government play in that system is bigger than any individual issue, because it's that system that we use to resolve every issue. And so to me, when an executive officer when the Attorney General is asked to defend a statute that he or she doesn't think is a particularly good idea, you don't really have that luxury of saying, no, I don't like that. I'm not going to defend that. If it's a statute that has absolutely no legal justification, then I think it's a different situation. But the case here was a lot more nuanced than that.
Well, I don't have anything to say about the law enforcement and the Attorney General's authority or purpose in effectuating, in following through with legislative commands. We as courts are often bound by legislative commands, and part of that is the theme of the majority and my concurring opinion.
Right, and that was in your concurring opinion, and the issue of the separation of powers. And to follow up on what Mr. Fuqua was talking about the tripartite system of government, in my dissent, I had to address that because that was an argument that was made at the oral argument and in the briefing. And it wasn't a question for me. What courts do is they decide constitutional matters. They do not defer those matters to the legislature to decide. This is our job. This is what we do. And in the dissent, I talk about that this was not an issue for the legislature to decide. The courts needed to decide whether this right existed. And in my view, in the dissent, it did, and it does.
Well, all I would say is courts have decided that issue. I mean, the majority opinion and the dissenting opinion decided that there was no constitutional right, which is also consistent with, I think Ms. Tucker said 15 other cases. I'm not sure whether that's correct or incorrect. But certainly courts do decide those issues and have differing opinions. I think there were a number of federal judges we've cited along the way, including many on the Ninth Circuit, that found otherwise, and that happens in law and in constitutional interpretation also.
And I think that the discussion just points out that there's a difference between saying that this right doesn't exist and saying it's not my job in interpreting the Constitution to decide whether this right exists. I think that you were correct in saying that you found that the right didn't exist, but the justification, in your opinion too, and in Mr. Fuqua's argument, was that the legislature is better at making these kinds of decisions. And that simply is not grounds for overcoming what Judge Vanzi just described, the obligation of the courts to actually make those decisions.
Let me try another question that maybe all the panelists can answer. How is the liberty interest in aid in dying different from the liberty interest in choosing an abortion? Is the liberty interest in abortion so clearly more fundamental than in aid in dying? If not, which case is wrong, Roe or Glucksberg?
We're not going to answer that. But I think Judge Nash, who was the trial court judge in this case, is here, and you can find her during the break, and she had some words about that.
No, go ahead.
It's easy for me, and you all know what I'm going to say. Roe was right, Glucksberg was wrong. There's the simple answer to that question. How did Roe? Why was Roe different from Glucksberg? There are justifications, of course. There are different arguments. There are different underlying rights. It is really hard to argue that Roe, the right that was described in Roe, was somehow far more clearly fundamental, more basic to what it means to be a free person than the right described in Glucksberg. I just don't think that, I just cannot understand what the life experiences would be of someone who doesn't recognize the importance, the gravity of the right that was raised in Glucksberg. What was the difference? The court was different, the time was different, and the court began to look at its role differently. And in fact, we had a court that was much more comfortable with Judge Vanzi's approach, I'd say, and when Roe was decided in the early 1970s, and we had a court that was much more comfortable with Judge Hennessy's approach when Glucksberg was decided later. They're two different judicial philosophies, and they'll, of course, be the subject of this afternoon's discussion.
And let me say, there's an interesting line in Obergefell. The court has not yet reconsidered Glucksberg, and the court has not yet spent a lot of time talking about Glucksberg. But in Obergefell, the court said Glucksberg may have been right. It didn't reaffirm it. It didn't cast great aspersion on it. It distinguished the right at issue from the right to marry, which was a pre-existing fundamental right. But I thought that was an interesting sentence in the Obergefell opinion that calls into question. And I know I see Ms. Tucker she's given up on me falling on my sword as she's asked me to do, but she may have interesting things to say about that sentence as well.
Well, and I do want to point out, Glucksberg was not at issue in Obergefell, so that court had no reason to even discuss that issue at the time. And I think I think one of the things that we're sort of missing here is we're spending a lot of time on Glucksberg, but we're forgetting this was brought under the state constitution. And we have to talk about what this discussion, what this argument, and what these rights look like under the New Mexico State Constitution, both under Article 4 and Article 18.
All I was going to say is, Professor Schwartz, because sort of what you ended with is what occurs to me anyway. I don't know that there is a case to be made that the gravity or importance of the rights in the abortion and end-of-life context are different. I think the sort of unsatisfying answer is what you highlighted, that it's a different court. And my torts professor always hated that explanation for why he'd say, here's a case and here's another case, totally different courts, 50 years apart, considering kind of related issues. And you'd say, well, so what's the difference? And so he'd say, well, it's a different court. And he hated that answer. But it's true. That different courts see things different ways, and particularly at different times. And so this is admittedly a sort of clumsy dodge of the thrust of the question, which was whether there's actually a difference between those two substantive rights. I would have a hard time articulating what it is. But it just hasn't been the case yet that the same court has considered both of those rights at the same time. And I really do personally believe that the reason that we have different conceptions of those rights is, they arose in different social milieu. There are different people deciding them. There are different reasons why they come to the fore. And just as human institutions are sort of messy sometimes, I don't think, the United States Supreme Court is any different ultimately.
Well, I'll say that a differently constituted court, that issue goes to Justice Rehnquist's longstanding caution about the policy preferences of a given court at a given time and the potential to create instability in the law. That's what he wrote about. He used that language in Glucksberg, and I've seen it elsewhere also.
Yeah, and his view of constitutional interpretation has become ascendant. And so how do you read a constitution where you're sure that in all times and all ages, all judges will look at it in the same way? You have either completely valueless judges, which is one possibility, which I don't think we want, or you choose judges who are very likely to find no new constitutional rights, not to apply the Constitution in any way it hasn't ever been applied before. And so I do think that is the foundation of the Rehnquist approach to constitutional litigation, the Scalia approach as well. And I think that for better or for worse, and I think for far worse, it has become ascendant not only in the U.S. Supreme Court, where we can see it, I think, fairly clearly, but even more so, or at least as much so, in the New Mexico Supreme Court and in the state judiciary across the country. It's a substantial change in judicial philosophy in the last many years.
I will say that even that approach, though, leaves open the possibility for that change as the social mores and the things that the constitutional interpreter would be looking to change over time, because they obviously do change over time. And that may take a little while, but it seems to me at least an echo of the sort of common law process you were describing earlier that would substitute for the legislature providing the kinds of details that we might want to see in the description of the contours of the right to medical aid in dying. And so yeah, it may not be it doesn't seem to be the system, Professor, that you would prefer, but even if the system is looking to historical context, history doesn't change, but it continues to move. And this is underlying some of what I was saying earlier about the different courts in different times, is that, medical aid in dying is an issue that has been building steam for a very long time, and there may be a Gestalt kind of moment like there was with same-sex marriage, just a few years ago, another issue that Ms. Schauer and I both were involved in, where there is this sort of what feels like a sudden sea change in the way that people are viewing the importance of a right, the existence of a right, and even if the court's analysis, or a court's analysis, constitutionally, is looking to the way that society has dealt with a particular issue over a period of time, that can and does change.
Let me try another question. Is the New Mexico heightened rational basis test really any different from the U.S. Supreme Court rational basis test? To the extent it is different, is it better, and why?
Yes, and it's better.
No, it's the same.
Next question?
Would you like to give an explanation?
No, that came up actually in a few cases for me. The other most prominent one was had to do with the refusal to provide workers' compensation to farm and ranch laborers, which was a case I handled in the trial court, and then went a different direction. There was another case that finished up after I had left in the appellate courts, but. The heightened rational basis test in New Mexico it's a little slippery, but I think you could say the same thing about the rational basis test that's applied at the federal level. And certainly, as you start getting into the difference between intermediate and strict scrutiny, and Why do we have 3 levels? Why don't we have 15? Because you can, to me, it's almost infinitely regressive. And obviously you've got to pick a point at which, this is as far as we're willing to go in making the distinctions between importance of rights or the strength of a state's interest or whatever. But to me, the heightened rational basis standard in New Mexico requires something more than just a hypothetical justification for either a distinction that is drawn in a statute or some sort of incursion on a right that otherwise exists under the Constitution. You have to do more than just say, well, it's possible that this could happen. You have to provide some sort of evidence that justifies the distinction that's being drawn. Sometimes that evidence is kind of hard to point to, but I do think, at least conceptually, it's a better approach than just saying, hey, state, if you can come up with any reason that isn't insane to justify what it is the statute's doing, we'll put our stamp on it.
I see the professors looking at me. There are many things the New Mexico Supreme Court does which I have no capacity to understand. And I think this falls into that category. Rational basis means rational basis to me.
I have another question I think the judges probably will not answer, but Professor Pope brought up earlier sort of the non-rationality of the difference between a person's interest in refusing life-sustaining medical treatment versus the prohibition of doctors from prescribing medication to competent terminally ill adults. Could you talk about that distinction? Are there differences? What are they?
I feel like I'm sort of dominating the conversation up here, which I don't want to do.
Well, I don't think that that's a question that either of us would answer. Is that fair to say, Judge Vanzi?
All right.
I'll respond to you.
Okay. As Professor Pope described it, sort of generally as that the omission-commission kind of distinction. I think there's a little bit more to it than that. Whether it really withstands, tough analysis, I don't know. But I'm reminded of the trolley problem. Judith Jarvis Thompson's. The problem is you're standing at a switch operating on a trolley line, and you see a trolley coming down the track, and you have the ability to direct it from the track that it's on to another track. The track it's on, there are 3 workers who aren't going to be able to get out of the way. They're going to be run over by the train if you don't redirect it. The other track has 1 person on it. What are you morally obligated to do? Are you morally obligated to flip the switch and kill 1 person or do nothing and let 3 people die? And the question, that problem is designed to hone in on this omission-commission distinction, right? But are you morally cleansed because you didn't do anything, even though your inaction allowed the death of 3 people? Or is it wrong for you to have taken an affirmative action that caused another person's life? And that is the distinction that I think is supposed to underlie the difference between palliative sedation and affirmative medical aid in dying. And that is a distinction, it's pretty fuzzy, admittedly. You know for a fact that the medication that you're going to give this person in the palliative sedation context will lead ultimately to that person's death. And we think that that's okay. And I think it's okay. But at the point that what you're doing is giving a medication not to treat pain directly, the only purpose of which is ultimately to terminate the patient's life at that patient's election and for the reasons that the patient has identified, typically or almost exclusively, I guess, in this context, ending this unbearable suffering and pain. The only difference that you can point to is, and I think Professor Pope highlighted this, is that the intent of the physician. In writing that prescription for Seconal or whatever it's going to be, the intent of the physician is that the patient will take that medication for the specific purpose of dying. And in the case of palliative sedation, you're writing that prescription in order to alleviate the symptoms, knowing that the end result, even not that far into the future, is going to be death. And so whether the patient ultimately takes the medication that's prescribed or not, the reason that it's written is because the patient requested it, and the only purpose that the medication would fulfill if it's ingested is, of course, to end the patient's life. Whether that's a persuasive distinction or not, I'm kind of, that's hard for me.
I do think that as Mr. Fuqua suggested, the whole issue is intent. The distinction is based on intent. What is the intent? What is the intent of the actor? And why does it make a difference? In one case, you're intending death as the immediate consequence of your act. In the other, you're not intending death, even though you know it's the natural and probable consequence of your act. And there we have an interesting legal history, and we have Judge Rehnquist, once again, Chief Justice Rehnquist, substantially changing the way we view this and adopting what was really a medieval theological view and making it into U.S. constitutional law. That's really what happened in this case. The old legal principle is you're deemed to intend the natural and probable consequences of your acts. That's not true of the traditional theological view, where you look to the soul and you look to the actual intent and whether the intent is to cause the death with the immediate act or not. I would have thought that the courts would have taken the legal approach and say you would intend the natural and probable consequences of your act. But the courts didn't take that. I mean, Justice Rehnquist and the U.S. Supreme Court did not take that approach. They took the other approach. They said we are adopting this doctrine of double effect, heretofore a theological doctrine, and recognizing it in American law, in American constitutional law. That was, I think, an unfortunate decision and an unfortunate turn in American law.
So now we're going to give a lucky audience member the opportunity to try to see if you can ask a question that the judges might answer. There are law review students who have mics.
Good afternoon. I'm William Strip. I'm an attorney out in Rama. In the last year, I've been involved in 3 end-of-life cases involving cancer. And my understanding of New Mexico law as it now stands is there's no prohibition on terminating your own life. So you could do it with a handgun, you could do it with an overdose of narcotics and a 1.5-liter bottle of gin. You can walk in front of a train. But what we're dealing with is third-party assistance. And so when I'm giving counsel to people, we have codified the Optional Advanced Healthcare Directive under 24-7A4. And so in that, under end-of-life decisions, which is paragraph 6, you can choose to prolong life, not prolong life, let your agent decide. Under paragraph 7 is artificial nutrition and hydration. You can say, I want it, I don't. But when I asked before, it's paragraph 8, and that's the relief from pain. And what that says is, and I will read it, is regardless of the choices I have made in this form, and except as I state in the following space, I direct that the best medical care possible to keep me clean, comfortable, and free of pain or discomfort be provided at all times so that my dignity is maintained, comma, even if this care hastens my death. Now what happens in all 3 of the cases I had, the individuals passed away at home, and generally speaking, the prescriptions are fentanyl patches. If you have cancer, you're given multiple fentanyl patches. And the question then becomes, in terms of this distinction about terminating life or hastening death, if you have a family member or if you have a hospice care provider that is putting those fentanyl patches on, so say you put on 3, say you put on 10, you could argue that that person is terminating the life as opposed to hastening death. What are your thoughts on that?
This was actually something that we discussed a little bit in the trial court, at least I thought about in the trial court. To me, and this is not going to be a very satisfying answer to that question, recognize that at the front end, but to me, what that points up are some of the problems that the state would face in trying to prosecute a medical professional for a violation of the prohibition on assisted suicide through the provision of that kind of medication. Because getting back to this question of intent, now not as a question of a distinction between one right or another, but a question of what the state's burden of proof is in being able to establish a criminal violation of the statute such that the medical professional's liberty is now at risk. You have to prove, I think, that the physician took the act with the specific, not general, but specific intent of assisting another person in ending their own life. And it seems to me that that's very, very difficult, if not impossible, to prove in the kind of scenario that you've described, where you have a caregiver who's applying this pain medication that was prescribed by a physician ostensibly for the purpose of pain management and not for the purpose of ending the person's life, but could very easily be used to end the person's life. It might be a violation of the statute, but I have no idea how the state would ever prove it.
But it isn't much comfort to a doctor to be told, look, you might be charged with murder, but I'm pretty sure we can get you off. That is not the way you develop good medical practice in the state of New Mexico, and that's, I fear, where we are now. The real underlying problem is what made that a crime initially, which is the interpretation of our assisted suicide statute. That is the essential problem which gives rise to all of the difficult issues here. And it doesn't look like we're going to have time to address that, at least as part of this panel. Perhaps it'll be an issue later today. But in fact, that does go to the New Mexico Supreme Court's interpretation of that statute, which is one that I certainly view as undermining good medical practice in New Mexico.
Please join me in thanking our panelists today.